Good afternoon. Welcome. It's great to see all of you here. And we are thrilled to have with us for this week's forum, Preet Bharara, the U.S. Attorney for the Southern District of New York. Preet, thanks for joining us. You got one woo.
I know.
That may have been planted, we're not sure. So Preet is known to all of us, and I won't take too much time in the limited time we have with an extended introduction, but he's of course had and is in the midst of having a spectacular career of public service, to be sure, that has had many elements. Started with several years in private practice, and then as an assistant U.S. attorney in the office he now runs. He worked for Senator Schumer in Washington. I think that's when we first met, Preet, when you were in Senator Schumer's office, and then since 2009 has been the U.S. Attorney for the Southern District of New York. That's an extremely long tenure in that job, in that very demanding job, and of course we all read on a fairly regular basis about the work of that office, which is a large and complicated and sophisticated place. You spent several years in a large firm as an associate, and then after graduating from Columbia Law School, and then moved into the Southern District as an AUSA. Was the plan always public service?
So yes, first I just want to say thank you for having me. It's good to be here at NYU. There's some people who used to work for me who are in the audience, so special shout out to you guys. I realize that that you're going to learn a little bit about me, and I'm going to learn a little bit about your eating habits. So it'd be fun to watch you guys eat lunch. I thought maybe I would have a sandwich, but apparently not. So when I was in law school, certainly, and I think even before that, I thought that I wanted to become a lawyer. And I've said many times, in 7th or 8th grade, I read Inherit the Wind and thought, that's kind of a cool thing to do, to be a trial lawyer. And then when I got to law school, I realized that the thing that I really wanted to be was a trial lawyer, and specifically a prosecutor. And I think I really decided that's what I wanted to do when I took trial practice in my 3rd year of law school. It solidified it for me with somebody who then was the chief judge in the Southern District of New York, then became the Attorney General, Judge Mukasey, who taught a class in which, and I hope many of you take this opportunity if you haven't already, to take trial practice. Even if you're not sure you're going to like it, you should try it. Because to my mind, there was no more exhilarating thing to do as a lawyer, and then to do it in a way where your only goal is to do the right thing in the right way and to advance the interests of justice, not represent any particular client, but represent the public in the United States of America. I thought, what could be better than that? The U.S. Attorney's Office typically doesn't hire directly out of law school, sometimes directly out of a clerkship, but not usually. So they want people to get some experience. Mm-hmm. So I went to a firm, and I had it very firmly in my mind throughout my time practicing in a firm, and I went to 2 firms actually, that I wanted to become an assistant U.S. attorney, and if I could in the Southern District of New York, because I thought there's no better thing to do than to wake up every morning and look around and try to figure out how you can make the world a little bit better, a little bit safer, and your community a little bit better and a little bit safer. And that's what people in the office strive to do. And I would encourage as many people as possible, whatever you think about doing, to spend some portion of your time in your career as lawyers in public service. It doesn't have to be as a prosecutor. It could be as a public defender. It could be doing environmental work. But there's a couple of reasons for that. One is there's no more gratifying thing than to take the education that you have been gifted by going to an institution like this and figuring out how to make the world a little bit better. It's as gratifying a thing as you can do. The work has meaning, whatever work you choose to do in the public interest. And then second, and I place it second, but it's important to a lot of people, you are more likely to learn how to be a good lawyer and how to have good craft and how to be a good practitioner in the public service, in the public interest, than you are going to be in the private sector. And that's just a function of the dynamic of how law firms operate and in-house departments operate. You're less likely to get into court. You're less likely to take the deposition. You're less likely to interview the witness. You have an amazing opportunity not only to give back in public service, but also to develop your trade, which is a pretty good combination.
So a lot of our students here, obviously one of the hallmarks of NYU is a commitment to public service and public interest, and a lot of our students take up the very call you were just reiterating. And you mentioned it's clearly the case that public service in the domain in which you've worked could be on the prosecutor side, it could be on the defender side. was there a reason that you gravitated towards thinking about being a prosecutor? And do you think that there's sort of one view of things on that side of the V and another view on the other side of the V? Or how do you relate that to the way you think of public service more broadly?
Yeah, I have great respect for people who practice in the defense world. In fact, when I was in private practice for some of those years, I practiced criminal law on the defense side. A lot of people who leave the U.S. Attorney's Office or a DA's office end up becoming defense lawyers, and vice versa. I hire back some of the best criminal defense lawyers in the city who come back and then give back to public service after they've spent some time in private practice. I think it's important to have some experience often doing both because A, you're better at your craft, you understand what the other side thinks, you understand how the other side plans for trial, might examine witnesses, might cross-examine your witnesses. But almost more importantly, I think if you have spent time in both areas, as a prosecutor, you have an understanding of what it is like to be on the other side so that you make good decisions and you make the right decisions and you have an appreciation for how big a deal it is, not just to prosecute someone, but to even commence an investigation. And it makes people, I think rightly, more sensitive to the fact that these are not just figments of your imagination. They're not imaginary figures. They're real people with real lives, with real people who depend on them. And that if you have that perspective and that experience, which everyone should have, I think in many ways it makes you a better prosecutor and a fairer prosecutor. And so part of the reason I gravitated towards becoming a prosecutor is, in my view, and not everyone agrees with this, in some ways prosecutors are the best defense lawyers around. Because if you care about justice and you care about doing the right thing, you should never have to stand up, and you should never stand up as a prosecutor and advance an argument or advance a case that you don't believe in with both your mind and your heart. And very few people get to say that and do that. And I don't think defense lawyers get to say that and do that except sometimes. And a prosecutor's office, as one of my predecessors famously said, should be judged not just by the cases that it brings, but by the cases that it doesn't bring. And as a prosecutor, you have the ability to exercise your discretion and not bring cases that you don't think are in the interests of justice. And I think, to my mind, there's a more gratifying thing than that.
That provides a good segue to start talking about some of the issues in the work of your office, I think. So one, we could put under the rubric of mass incarceration, or maybe even more generally, mass incarceration as a phenomenon of a criminal justice system, or systems, if we think about the federal and state systems as distinct, that many, including even our president, have suggested is broken. I wonder your perspective on that, and if it's a segue from what you were just saying, it's because it picks up on this idea of discretion. One place where there is a lot of discretion, obviously, on the prosecutor's side is in charging decisions and the like. One place in the system where there is less than complete discretion is on the sentencing end and the existence of mandatory minimum sentences in the federal system in particular, a number of the federal drug laws. And some point to that as one big cause for the extent of mass incarceration in the United States today. Obviously, you have a role within the system, but how do you think of this as a problem, or do you define it that way? Do you think of mass incarceration as an output of the current criminal justice system as about right, in need of reform? How would you tackle the problem?
So there's a lot of questions in that one question, which I'll try to answer.
I'm a law professor.
In less than 75 minutes. So first of all, I think that what we're talking about is a criminal justice system. And the operative word there is justice. And you'll hear me talk about this a lot. And I work in a department that is called the Justice Department. So everything that we do, I think, should constantly be in a state of re-examination and reform, whether it becomes popular in the public perception at a particular moment or not. And so with respect to what people refer to as mass incarceration, I think it is a good thing that everyone from the president to members of both major political parties in the country are thinking about whether or not we are prosecuting people and holding them accountable and sending them to prison for the appropriate periods of time. Is that right? Is that wise? Is that fair? Is that cost effective? And all those questions I think have been important to ask for a long time. And there's a moment now that a lot of people are identifying where more people than usual are thinking about that and are re-examining that. So I think that's a great thing. In my office, if I ever ask a question, people in my office know, if I ask a question about why we're doing something in a particular way, and the answer I get is because that's how we've done it, I get very angry at that answer. And I think that that same principle applies to broader issues of how we treat people, prosecute people, how we do everything, how we do education, you name it. It should be justified on its own terms, not just because that's how we've done it in the past. With respect to mass incarceration, what people call mass incarceration, I think on the federal side, people need to distinguish the federal side and the local side. On the federal side, I think it's only 10 to 14% of all people who are in prison in the United States are in federal prison. So even if you eliminated every federal defendant in the country, you wouldn't do that much on this issue. At the same time, I think the reports are that the number of people going to prison federally for federal crimes is on a decline, and for the first time in a long time, and I think people may have read in the newspaper today that depending on what happens over the next few weeks, 6,000 federal inmates are going to be released. So there's clearly an understanding and a trend based on what judges are thinking about, the Sentencing Commission is thinking about, the Department of Justice is thinking about, for a little bit of a trend down in how long people spend in prison. I think, apart from that, just to jump to another point, we need to think deeply not just about how long people should spend in jail for crimes they commit, or whether they should go to jail, but if they do, what should be the conditions of their confinement? How do we treat people who are still human beings who are in prison? And we do a lot of work in our office, but not all of it gets the same amount of attention. But I hope that people are aware of the work that our office has done, our Civil Rights Division has done, with respect to the conditions on Rikers Island. We have fought really, really hard with the city and with the Department of Corrections to make sure that everyone understands that even though people may have committed crimes, they're presumed innocent until the trial happens, and there are a lot of people at Rikers Island who are pretrial, but that being behind bars does not mean beyond the Constitution. And the Constitution applies to every person in the country, whether you've been convicted of a crime or not, whether you're in jail or not. And some of the conditions that we have found, and that led to our, I think, landmark resolution with the city at Rikers Island were really abhorrent. There was use of force that was way out of control. There was a lack of discipline, all sorts of things. You can read the very lengthy report. And we accomplished something there whereby, among other things, solitary confinement, which people have been debating a lot now, in the same context that they're debating mass incarceration, has finally been eliminated for adolescents at Rikers Island. So that work is really important, and it's among the types of work that we've done in my office that I'm most proud of. We also have been looking at the Westchester County Jail. People may note that we have been taking a look at an incident that happened at Fishkill, which is further upstate, and it makes you wonder and think, while we're talking about incarceration, is there a systemic problem generally in the country, but more specifically, because I'm in New York, is there a particular problem with the State Department of Corrections and how they supervise these various facilities in the state and how they treat people who are in their custody and care and control in the state, and whether or not it's time that there is a very hard look at how that Department of Corrections operates its facilities here in New York.
So speaking of state government, an area in which your office has been quite active in the last year in particular is around public corruption. And I'd love to hear, literally, there's so many questions I'd love to ask you about pending cases, and I'm going to do my best to avoid
You're going to ask one with 18 subparts?
Exactly, yeah. You take notes. Maybe one question that's connected to the corrections issue as well is, so how do you think about the role of your office and the promotion of reform in other parts of it, here, another layer of government, right? So you bring individual prosecutions. One hopes for there not to be the kind of public corruption in the first place that would occasion the prosecutions that you've brought, or at least the allegations that your office has laid. So how do you think about the relationship between the sort of individual prosecution decisions and a systemic problem like corruption?
Yeah, that's a great question, and a kind of very complicated question. The principal role of the prosecutor is to prosecute. The principal role of people who care about public safety is to protect public safety. But it's also the case that in the course of bringing certain kinds of prosecutions, you observe why it is that some of that bad conduct happened. I mean, I never go anywhere without getting asked the question, if we're talking, whatever area of criminal conduct we're talking about prosecuting, people ask the question, as they should, well, why does that happen? And part of the role, I think, of anybody who cares about public safety and about upholding the rule of law is not just holding people accountable, that's a part of it, but another very important part, some would say a more important part, if you do it properly, is prevention. And prevention through, among other things, deterrence. Because if you, as I say to people who do narcotics prosecutions all the time, if you are able to make a neighborhood safer for people and get rid of a gang problem, and people, the next day feel more comfortable letting their kids go play in the park or go to school because you've put away a bunch of people who are terrorizing the neighborhood and selling large quantities of narcotics and shooting people, which is happening in parts of our city and in the district, that's great, and a job well done, and you've held people accountable. But if the next day 10 new gang members take over that same block, then you really haven't accomplished that much from the perspective of the people who want to send their kids to school without being shot at. And I think the same principle obtains in every context. If you hold people accountable, great. But if you haven't done something to try to make the problem better, then that's not a great situation. And that's true, I think, also in public corruption. So part of what you do is you make sure that everyone understands why you brought those prosecutions, and you make other similarly situated people understand, hopefully, that I don't want to be in the position of that person who just got hauled away and whose life has been ruined because of intentional conduct that harmed people, what they did. So I think that's an important part of the job. Now, I worked in the Senate for 4.5 years, so I used to be a person whose specific job description included advocating for particular pieces of legislation, drafting amendments to legislation. So, I try to stay away from that. But I do get asked the question, what kind of tools do you think you need? Why was it not possible to hold a certain kind of person accountable? And I think in those occasions, it's appropriate to describe what some of the obstacles are to doing our job, what some of the obstacles are to public safety. And I've done that in the public corruption context, I've done that in the drug context, I've done that in others. Last point on that, another new thing that's happening around the country in the narcotics area is the proliferation of what's called K2 or spice. Some people call it synthetic marijuana. And it is a public health hazard that the likes of which we haven't seen in a very long time. And so when we announced a sweep in that case, we arrested a number of people, and we did this jointly with the DEA and with the NYPD. The number of people who were going to emergency rooms because they were overdosing on what they thought was something innocuous, and it's not, K2 spice, was going through the roof. And people were dying in overdoses of this drug that's being manufactured with chemicals in China and then being sprinkled on leaves and being sold as something that you don't have to worry about in bodegas and in convenience stores around New York City. We had to make I think it goes to your point, we had to make a decision about how we go about broadcasting to the world these arrests. And we didn't just do the arrests. I stood up with the commissioner of police, with Bill Bratton, with the head of the DEA, and with other people to not only say, you should know that we've arrested these folks and these are the charges that are contained in the complaint, but also to let people understand so that parents and siblings and young people would know that if you do this stuff, you don't know what kind of chemicals are in there, there's no controls on them, and you could end up in not just the hospital, but the morgue. And the more people who heard that and understood that and read about it in the paper, the more likely it is that a life would be saved, and I think that's completely appropriate.
That's an interesting view on not just public corruption, but more broadly. Now, speaking of the papers, your name appears in them with some frequency. I'm told that the New York Observer, ranking the most powerful people in Albany, has Governor Cuomo second and you first. There's congratulations, I guess. This is one of my favorite headlines of the fall. The Preet is on. So, some of your critics have suggested that you might overuse the media, the press, that there's some line of propriety in terms of how much a prosecutor ought to be talking about cases just filed, but cases pending in any way, or even about issues not having to do with pending cases, and that wherever that line is, you're on the other side of it. Yeah. So that's the criticism.
What's interesting about that is often, and look, prosecutors have to be very careful about what they do and how they talk and what they say outside of a courtroom. And I adhere as scrupulously as I can to all of those rules. But as I said, I have a job not just in making sure the people in my office hold folks accountable, but in making sure other people don't commit the same crimes. And I have, I think, an obligation and a responsibility to make sure that I'm doing that part of my job too. And the interesting thing about, generally speaking, the criticism that arises of that nature doesn't arrive in garden variety cases. It often arises in cases where people have very, very, very sophisticated and high-priced lawyers who can afford to make accusations like that. And then there's a forum for them to litigate them, and then, if they're correct, then someone will find that to be so. That criticism never arises, interestingly, in the K2 context, right, or in the gang context. And prosecutors in this country every day walk into high schools and walk into churches and talk about a crime problem and talk about ways in which you can solve crime beyond simply locking. In fact, what we're talking about, when we're talking about mass incarceration, we're talking about interesting dichotomy here, right? On the one hand, people are saying, I think, intelligently and wisely, that you can't prosecute your way out of every problem, whether it's public corruption or drugs or prescription pills or terrorism or anything else. That what is necessary also is some kind of engagement and public education and deterrence and changes in culture. And when prosecutors and local DAs walk around and they talk about how there should be better after-school programs, or they talk about how education is important, nobody ever says, what are you doing? You're overstepping your bounds, because that would be ludicrous. And so I think that same principle doesn't just apply when you're talking about street crime. You're talking about, and when a prosecutor goes and says, you should make sure that your kids go to school and get an education so they don't fall to gang life, people applaud that. And I don't understand why, and by the way, when I do it with respect to Wall Street crime, the people who ask me the most questions that are technically out of my lane, right? What statute do you apply, and how long a prison sentence should someone serve, and what are the elements of insider trading? The people who most ask me the questions outside of that and ask me, how can businesses do better? How can we change the culture on Wall Street? Are people who are on Wall Street. And when I go and speak to hedge fund managers, groups like this, this large, but who are from the hedge fund industry or the trading industry or the banking industry, they're the ones who, when we do the Q&A, say, separate and apart from prosecution, how should we be behaving? How can we inculcate in our institution better character, better culture? So interestingly, and I think the criticism you're talking about arises in the public corruption context, I don't frankly get why it's different in the public corruption context, especially when those crimes go to the heart of democracy. And everybody, whether you're a prosecutor, a defense lawyer, whether you're working a blue-collar job or a white-collar job, whether you're old enough to vote or not, those people's decisions affect your lives. They make decisions about what kind of taxes you pay. They make decisions about speaking of incarceration, who goes to jail, who doesn't, for how long, whether our jails are properly monitored or not. And so to answer questions about why it's happening, why is there corruption in Albany or the city council or anywhere else, and what ordinary people can do to make it better and to raise public awareness of this problem, I think is completely appropriate, and I think I would be in some ways remiss if I didn't talk about those things.
You mentioned the trading industry. So that's one place where the answer that you gave at some point in the past about what the rules are, and the answer that seems to be the answer in the Second Circuit and that the Supreme Court declined to take up earlier this week, now changed over time with the Second Circuit's decision and the Supreme Court's denial of cert on Monday in a pretty significant insider trading case. One member of the faculty here called the loss for the government in that case a dagger in the heart of insider trading prosecution. I'm guessing that's not the metaphor you'd use.
Who's the member of the faculty? And is he or she here?
We'll get onto surveillance later.
I'd like to have a word. Isn't that out of the lane of a professor?
It's very wide lanes for professors, it turns out. So some in the audience will know about this case and some won't, but why don't you tell us a little bit about it and give us your perspective on the now, I guess, settled law of the circuit in the Second Circuit.
Yeah, so I don't want to go on at length about it, but we brought a series of insider trading cases over the course of the last 6 years, which I think are fairly significant. We've done a lot of other things too, but that's one area in which we've done, I think, important work. An argument was made in a trial court. Two people were convicted. At some point later, that the defense lawyers took it up to the circuit, which is their right, made various legal arguments, And one of the legal arguments that they made was that the tipper in giving a tip of material non-public inside information didn't receive any benefit, yet have knowledge of there being a benefit back. So in other words, the Second Circuit, in deciding to vacate those reverse those convictions, basically said for somebody to be held liable for and criminally liable for an insider trading violation, in addition to meeting all the elements that we always understood, you have to prove that the benefit that comes back to the person is something, I don't have the exact words in front of me, but we're something of material pecuniary value or potentially pecuniary value. So something other than mere friendship or relationship, but something that amounts to something that you could sell. And to our mind, that had never been the law before. The law had been, I think, we argued in our briefs to the district court, to the circuit court, to the full panel of circuit court, and then in our petition for certiorari that the Solicitor General filed, that had never been the law before under something called Dirks, which is the reigning Supreme Court case in this area and still is. And so we had an argument about it, like you do, and you'll find that you do in private practice or in public interest law in the future. We felt strongly enough about it, and the Solicitor General himself felt strongly enough about it, that we took the unusual move of petitioning to the Supreme Court to have the Supreme Court decide, because we think there should be clarity in this area, and we think that the Second Circuit, which is a very distinguished court and has a lot of great judges, made a mistake in this case. And judges are human beings just like everyone else, and sometimes we don't agree with them. We still think we have the better of the position, even though the Supreme Court declined to hear the case.
Were you surprised that the court denied cert?
No, not surprised. I think if you talk to a lot of experts, it's an uphill battle to get the court to hear any, I mean, you clerked on the court, because they have a lot of cases to consider, and they can't consider all of them. And I think any time you seek cert in the Supreme Court, it's an uphill battle. But 2 points I want to make about that. One, to the extent that the unnamed professor said it's a dagger to the heart implies that you could kill the body. We have brought about 100 insider trading cases since 2009. And even after the vacating of these two defendants' convictions, and some other cases will be implicated also, but when all is said and done and all the dust has settled, our view is we'll probably be at a 90% plus conviction rate, all things considered, which is better than the conviction rate for a lot of people. So I think the dagger analogy, unless it's a very, very dull dagger, doesn't apply. Second thing is, in terms of deterrence and in terms of what people think about the insider trading docket that we've had, some of the most prominent cases that you've heard about, including the one against Rajaratnam, the one against Rajat Gupta, the case against SAC Capital as an institution, all are going to stand, notwithstanding this particular decision that the Supreme Court has declined to review. On the other hand, that's not to say that we think that everything is hunky-dory. There's a certain category of conduct.
The cert petition must have said this was an urgent question that needed the court's
did.
attention.
It did. Because look, because you want to make sure that the markets are fair and that people have faith in the markets. And to our mind now, we think that the decision now that stands makes it very arguable that, I'll give you a hypothetical, makes it very arguable that a CEO who happens to be the head of a top 50, a top 50 company in the world, and decides to bequeath upon a relative or a crony or a buddy a tip about what the earnings numbers are going to be 2 days before they're going to be publicly reported to the world, and says, with every bit of knowledge that it's private and confidential information, with every bit of knowledge that the person to whom he's giving the information is going to trade on it, with every bit of knowledge and hope that that person is going to make a 10 or 20 or $30 million profit for having that special information that nobody else is supposed to have, and says, knock yourself out. If that person can now claim under Newman, as it can easily be read to say, I didn't expect anything back, it was just a gift, because it was my daughter, or it was my golf buddy, or it was my college roommate. You can get away with that. And people have to ask themselves the question, is that a good state of affairs? Is that how the securities markets should be? Is that how you get people to have confidence in the securities markets? And we believe, because we prosecuted the case in good faith, and we understood what the law was at the time, which we believe the Second Circuit changed, that should be criminal. And apparently, there's a decent argument that you can do that and get away with it. And I think reasonable people can decide whether or not that's a lovely thing.
We're going to open it up for questions from students in a minute. I want to ask a question that maybe in one way is a kind of resource allocation question, but I'll ask it this way, which is, what worries you these days? What are even though the federal government is a government of enumerated and therefore limited powers, the reach of your office is broad. And part of your job is to set priorities. And presumably that priority setting reflects a sense of the problems most urgently in need of your office's attention. So either at that level or even in a sort of longer term way, what are the issues that you're worried about, that you think the government needs to be attending to, and the part of the government that you work in, at least?
Yeah, no, that's a good question. And many would say that that our office's sort of ambit is particularly broad. Somebody once asked me, made the mistake of asking me the question, what again is your jurisdiction exactly? And I said, are you familiar with Earth? So we, long before I got there, have a long tradition in the Southern District of thinking about the global reach that we have, because we do have a good amount of resources, not unlimited resources, but a good amount. And so you have to think from day to day and from year to year what the problems are. And so in recent times, and you move your resources depending on what you think is a public safety problem and what you think is a rule of law problem. And I've already mentioned one that's become a higher priority as information comes to us. For example, the problem, I think, in prisons around the state and in the city, in Rikers Island in particular. I'll give you another example, then we can take questions, which I think people have appreciated. When I started in the U.S. Attorney's Office as the U.S. Attorney 6+ years ago, people were beginning to understand how important the cyber threat was and how big a deal that was. At the time, we had basically one person in our office who was really, really expert on the cyber threat and how the internet, the intersection between criminal law and the internet, and how much bad stuff bad guys could do through use of computers and the internet. We now have 10 times that number of people. 6 years ago, the FBI and the Secret Service, who are the principal law enforcement agencies that try to protect us from the cyber threat, are now operating at multiple times the number of folks they had working on it back then, and the people they do have are more sophisticated. And I think people get it now after hearing about the Sony hack, after hearing about the hack of all the documents, mine included, at the Office of Personnel Management.
Mine included.
Yours included, especially yours. It's a gigantic problem. It's a problem for your bank accounts. It's a problem for your privacy. It's a problem for national security. It's a problem for infrastructure. And if you ask, and you also see that that is reflected in the way that people talk about the problem. You did not have a president of the United States or a secretary of state or a treasury secretary or the FBI director and all these people on a regular, myself included, at a lesser level, all these people, every time they speak publicly, they will talk about the cyber threat and the ability of bad guys to do bad things because of that, and how recruiting is being done through social media. Now, a few years ago, we finally got introduced to this concept of Twitter, and there were people in my office who said, we don't even know what that is, and thought it was kind of a weird thing, conservative prosecutors to be on Twitter. And now, listen to Director Comey of the FBI. Every time he speaks publicly, he talks about one of the biggest threats to the country and to the world is the threat of ISIL. And how are they recruiting people? They're recruiting people largely through social media, through Twitter. We have people who are garden variety gang guys who are trying to recruit young girls into sex trafficking rings, where they will be abused and treated very, very poorly, and horrifying crimes will be committed against them. And they're doing it now through social media. And so if we don't get smart about that, and we don't understand how technology works and how cyberspace works and how we can strip away anonymity when it's important to do it, to get people who are not only trying to steal your money, but some of whom are trying to destroy your country, then we have big problems. So that's what worries me the most.
And getting smart on that, is that a matter of sort of technological development and literal learning, or do we need other laws than the laws we have?
I think you need to do all of that. I think you need to get, and it's also an orientation of being understanding of and open to technology. And it's not just true of the government, it's true of, when I speak to companies about this when I get outside of my lane, and I tell them how they should deal with the issue of cybersecurity, one of the things I say to them is, it can't just be the responsibility, a little off your question, but I think it relates to it. One of the most important things is that when you're thinking about how to make sure that your company is not hacked, whether you're a motion picture company or you're a bank or you're a university, you can't delegate that to the chief technology officer or the IT people. It has to be something that's important to the CEO of the company, to the board of directors of the company, because it's a matter of risk management and corporate management like any other risk, like a risk of competition or a risk of regulation or a risk, an accounting problem that you might have. And it has to be in the bones in every company in the country now, and in every government institution. This issue of how you deal with this threat and how you deal with the cyber issue, all the cyber issues, has to be in the bones and in the DNA of whoever the leader is, the U.S. Attorney or the CEO or the Attorney General or the Director of the CIA. And on top of that, then yes, all those people need to be thinking in deep ways about where there are gaps in the law. Again, I generally don't talk about that, but there are people who right now are going to the Hill and talking about how we need to update our laws because they're fairly behind in this area.
Great. Let's take some questions from the audience. We have some microphones here, so there's a hand.
Good afternoon. I'm Mitchell Brown. I'm a 2L here. My question for you is, we talked a lot about holding people accountable and about deterrence and about public awareness of issues. There's an issue of prosecutorial misconduct in our justice system. What are your thoughts about prosecutorial misconduct as a form of public corruption?
Yeah. I noticed you're reading the question. Was that from that professor?
That's from me.
Oh, okay, I was making sure. Look, nobody takes prosecutorial misconduct more seriously than prosecutors who care about making sure that things are done the right way. A mantra that I repeat in my office and that was taught to me and was taught to the person who hired me was that every day your job is to do justice and do the right thing in the right way and for the right reasons, no matter what. That is the most important thing that you can do. And so any amount of prosecutorial misconduct is intolerable. And if I ever find out about it in my office, that's a gigantic problem. What I think people need to understand is the best way to make sure that you don't have prosecutorial misconduct is to make sure that the culture of you need to have the training and the rules and all of that. And this is true of a bank, and it's true of a law school, and it's true of a prosecutor's office. You want to make sure that the culture is such that it is unthinkable for a prosecutor to willfully or intentionally violate the rules or cut a corner. I'll give you an example of how we have all the trainings, right, like you have, and you're supposed to have, and new mandatory trainings we're supposed to have to make sure that everyone understands the rules. Because sometimes these prosecutors are young, they deal with a complicated case. People make mistakes sometimes. But the important thing to do is make sure that they know what questions to ask. I have a rule of thumb in my office, which was handed down to me when I was a young prosecutor by my supervisor. And it's essentially this. You can parse the words of Rule 16 or whatever the discovery obligations are very finely, like a strict constructionist, such that you can make an argument that you don't have to turn over some batch of documents or some batch of material. And I say essentially that if you have 3 or 4 prosecutors in a room in my office, and the conversation about whether or not a particular thing should be turned over or not, and it goes on for more than 4 or 5 minutes, meaning that there's an argument to be made within the rule that it doesn't need to be turned over, and there's an argument to be made that it does need to be turned over, you turn it over. There's no reason not to. And you don't have to glide up to the line, and you don't have to make arguments in favor of not doing the thing that's really no skin off your back. Just give it to them. And I think the culture should be, and is, I hope, overproduction of things. And I think that's a very important thing to do. The second thing that's very important to making sure that you don't have prosecutorial misconduct and you don't have bad things happen and people skirting the rules of justice, this is true again of any institution. The way you have an ethical institution is to make sure that you have ethical people. And so the most time that we spend on any particular thing is actually often not on cases, not any particular case, it's on who we hire. The hiring coordinator is right here, Neil Corwin. You should see him after if you have an interest. And he will tell you how many hours and hours and hours. I don't think this is true in other institutions where we have a decent size. You go through several rounds, and at the end, you interview with the United States Attorney. And we are looking at people who we hire as much for, if not more, actually, for their sense of integrity, their sense of fairness, their sense of respect for justice and the law and doing things in the right way and obeying the rules, as we are about their academic credentials. Every once in a while, I've told this story before, I always ask the question for people who want to be in our criminal division, how are you going to feel knowing the kind of power you're going to have? And essentially, by definition, if you do your job correctly, you will in many ways be the proximate cause for real human beings to be separated from their liberty for long periods of time. How are you going to feel about that? And every once in a while, somebody answers a little too gung-ho. And every once in a while, someone's like, I have no problem with that. And that'd be great, because they did bad things. And when I sense that, you know what we do? We don't hire that person. And we don't care what clerkship they had, and we don't care, how, what their class rank was at NYU Law School or any other law school, because that's a problem waiting to happen. And I hope that people appreciate that and know that. So it's important to have rules, it's important to have a good culture in the place, and it's even more important to make sure that the people you're hiring, even before they've gotten the training and before they understand what the rules are, they've never been a prosecutor before, to make sure that they have good hearts and that they are ethical people who are full of integrity and want to have that reputation for the rest of their careers.
That's a very powerful, I think, very meaningful statement. That if you think less about your office and more, obviously you don't speak for offices other than yours, but just give us your sense of nationally. It was Judge Kaczynski on the Ninth Circuit who said, I think a couple of years ago, that we have an epidemic of Brady violations in the land. That this is, in other words, a huge problem. It's going to be solved maybe in the ways you talk about, but that it's a problem of that scale and scope. Do you agree with that?
Yeah, I only know what I see in my office, and I don't find that to be a problem in our office. I know a little bit more about the Justice Department as a whole, and there were issues with disclosure. I know in a case against Ted Stevens, right about the time that I became the United States Attorney, and the department, to its credit, I think, all the way up to the top of its leadership, took a lot of steps to make sure, to do all these things that I've been talking about, making sure that the message is understood by every prosecutor in the federal system, that you do things the right way, and then also make sure that even inadvertent mistakes are not made by having better training. Everyone had to revise its office's discovery policy. We had countless hours of meetings to make sure that we spent time with every single criminal prosecutor in our office, that's a lot of them, to make sure they understood the rules, to make sure that you never get up close to the line, to make sure that the public knew what our role was going to be. And I think that has been effective in the federal system. I'm not fully familiar with all of what Judge Kaczynski has said. I think there's some people who tend not to agree with him on that and on some other things as well. But I think we're doing a decent job.
Other questions? Here, yes.
Hi, Emma Moore, 1L. I'm a huge fan of your work in Albany, and I was wondering, the sort of work that you've done, pulling indictments for people like Dean Skelos, understanding that case is going to trial in a month, so not asking for specifics, but you've been able to do work there that a lot of both state and federal officials have been trying to do for years. I was wondering if you could comment on the sort of tactics and strategies that have enabled you to be successful, get indictments where others have failed.
Yeah, I can't speak about what other people do and what their focus is and how they arrange their priorities. I mean, I'm lucky to have, none of this, I didn't do any of this, by the way. I have amazing men and women in my office who are prosecutors, investigators, paralegals, staff, FBI agents, and they did all the work. And I think you see this in all the areas of law where we operate. I like to say we always work within the constraints of the law, but like to think out of the box. The folks in my office historically have been and continue to be aggressive. They also tend to be tireless, and they also tend to be fearless. And I think if you combine all of those things, and you do the tedious hard work of every day, looking at every document, making sure you're asking for all the right documents, making sure you're connecting all the right dots, making sure you're looking at where the money is going, and you have patience, you can make these cases. I'll give you, as I'm talking, I'm realizing another thing. There are a lot of cases that we start, and we investigate a lot of things. People think they know everything we're looking at. You don't. There are many, many high-profile things that we have looked at that you have no idea about, and we quietly close the case because it's not proper to bring a case, either because there's not enough evidence or because no crime was actually committed. I mean, we read the newspapers too, and we see, we have whistleblowers come in and tell us things, and we open up those cases. Now, some of them, on day one, you don't know if there's ever going to be a case. You don't know if the law is there for you. You don't know if the facts are going to be there for you. You don't know if the statute of limitations is going to be long enough. And I think it may be, I'm not criticizing any office, but I do sometimes think that an advantage that I have in my office that I inherited, I didn't create this, is that we're prepared to make the investment even if there's not going to be a payoff at the end. This goes for complex financial fraud. We brought this case against Toyota. It took us 4 plus years of slogging through documents, getting them translated, first brought from Japan, translated from the Japanese, because I have tireless, dogged investigators and prosecutors. I think there are places where they have more limited resources or they don't have quite the time horizon, and they think, is it worth spending months and months and months on something that may never pan out? We don't have that attitude. If something is worth looking at and we think it's significant, even if we don't know at the end of the day there's going to be a provable crime, we still do it. And some of those things pay off. And I think that's what you saw in some of these public corruption cases, all of which, by the way, are really difficult to prosecute and really difficult to prove.
Other questions? Right here, yes.
Hi, my name is Susan Emenegger, and I'm a Hauser Scholar at the Center, and I'm from Switzerland. I'm also a fan of yours. I have 3 questions. The first,
Let's start
they're
with one
short.
and see how we do.
they're short questions. The first question is from an outside perspective. When you bring world financial institutions to justice, there's also multiple authorities, sort of prosecuting them. So how do you experience this cooperation and competition between different prosecutors, Department of Justice, SEC, and so on, when you go after a case? Is there a moment where you pull back because somebody else is doing it? The second question is, you talked about resources, so my question would be, do you get a part of those huge fines that you're actually reaping? Does this go to your office or not?
No.
You-
That
you
is unjust.
personally
don't.
See, that was a short question.
If you
And-
saw the car I drive to work every day, you know the answer to that question.
And the third question, you've had an unusually long tenure, the dean said, so my personal question to you would be, where will you be 5 years from now?
I don't know. Maybe you'll be back here doing a thing. With respect to your first question, and I appreciate that you're a fan of the work. You clearly are not in the Swiss banking industry. They're not fans. So really? Okay. Well, there's a particular bank that's not a fan. So look, it's difficult, particularly when you do those kinds of financial cases. We brought a case against BNP, the largest bank in France, also. They're also not fans. And it's the nature of the world now, not just in the financial area, but especially in the financial area, that there are a lot of regulators, there are a lot of prosecutors, there are a lot of people who have some stake. In that case, you had the Manhattan DA's office, you had the U.S. Attorney's office, you had Main Justice, you had the Fed, the Federal Reserve, and you have to coordinate very carefully, because if you have just a rogue going out and willy-nilly doing a lot of things and taking actions, and we also had the Department of Financial Services in New York, and you're not coordinating, you can cause havoc and unintended havoc, and that's not a good thing. Sometimes it becomes difficult because everyone has a different mission, and the SEC has a different mandate, it overlaps some, but the SEC has a different mandate and a different mission from the U.S. Attorney's Office, which is different from the Manhattan DA's office, by the way, can keep all the money and is spending it lavishly. I don't mean him personally, but the office. So you have to be very careful about that, and I think it's only responsible and mature. And I think some people, you watch the movies and you think there's all fighting and bickering all the time in the Fed show. Our experience has been, separate and apart from the financial context, has been terrific. In the cyber area, we have done things I think would have been unimaginable a few years ago, not just coordination locally in the United States, but internationally. We brought a gigantic cyber case, I think 2 years ago, called Blackshades, that involved, I stood up when we announced the case and I had a global map consistent with our jurisdiction. And it had 19 different countries shaded because law enforcement actions took place in a coordinated way, given the time difference and everything else, in 19 different countries to take down cyber criminals in all those different places or do searches, court-authorized searches in all those different places. And that was coordination between the FBI and maybe the Secret Service and the prosecutor's office and different ambassadors. It was a crazy, complicated, difficult thing to do, but as we become more global and the world becomes smaller and criminal conduct can take place, a single criminal act can actually involve 13 countries now, right? Because you have money flowing, and you have visiting happening, and you have emails going through. We're going to have to get even better and better at that kind of coordination if we're going to make the world a safer place.
We've got time for maybe one or two more.
Hi, I'm Amine. I'm a 3L here, and you've been in public service for a long time. So I was wondering if you could talk a little bit about how sort of politicized it has become over your tenure, and what advice you have for somebody who's starting out and kind of sees that, and it's a little daunting to see sort of it pulling apart between parties and all that kind of stuff.
Yeah, I mean, there are different ways to serve in public service, and I'd like to think that I serve right now in the least politicized office that you can serve in. You know, we are known often as a sovereign district of New York. We are known as, and we're proud of being known as the most independent prosecutor's office around historically. Again, I didn't invent that, but I hope I've carried that tradition on. And that means independence, not only from politics, but independence from you know, wavering public opinion. And I would, you know, search for places where you can have that autonomy and you can have that independence. But even the Department of Justice is not immune to that kind of thing. When I served in the Senate, the most formative experience I had, now going back a few years when you people were a bit younger, was an investigation while I was in the Senate on the Judiciary Committee, investigating the Justice Department itself for its you know, sudden firing of 9 United States attorneys back in at the end of 2006. And that entire investigation, which I helped lead with the senator and with other staff members on the majority side, was about whether or not the Department of Justice had been politicizing the way in which it went about cases, had been politicizing the way in which it hired people, and had been politicizing the way in which it got rid of United States attorneys. And sadly, one of the outcomes of that, that's detailed at great length in Inspector General's report, is that there were people at the Department of Justice that I loved, that I served in, and I didn't expect to, but am proud to serve in again, was hiring people, and this may be especially relevant to folks like you, into their honors program and into their internship program, which are very difficult and prestigious things to get. And you should all apply for them now, because now they fixed the problem. There were people in the department, admittedly, and this was found extensively, who were paying attention to what the political affiliations and what the ideology was of the particular applicant, which is, that's a dagger to the heart of the integrity of an institution that's been around for a very, very long time, and whose very name has the word justice in it. I mean, in our office, we don't know what religion you are. We don't know if you're a Democrat or Republican. We just care about doing the right thing, and that's what the Justice Department has always stood for and should always stand for. So try to search for a place where you can be as independent as possible, but also know that wherever you go, you can still be a voice to make sure that that place lives up to the ideals of independence that it should.
Last question, there is one. Yes,
I don't have a microphone, but I'll.
let's just
Tell
wait
me.
for one.
Thank you. Hi, my name is Stephanie Wiley, and I'm a 1L. And you spoke briefly about mass incarceration, which is a problem that disproportionately affects minority communities. I've read that a concomitant issue is lack of diversity among prosecutors. Can you just speak a bit about diversity in your office?
Yeah, so I'm glad you asked that question. And Neil Corwin, who I mentioned already, cares not only about making sure we're hiring the best possible people, but we have a deep commitment to making sure that our office looks like what America looks like. And we should be able to do better at that. And so I'm glad you mentioned it, because at every opportunity I get, and Neil gets, and other folks from my office get, we would encourage people, whoever you are, whatever your sexual orientation is, whatever your ethnicity is, whatever your religion is, whatever your gender is, to apply to become prosecutors. And I think that not only would you get a better sort of overall vision for how people should prosecute things, but I also think there would be greater public confidence in prosecutors' offices. I think it's probably more in the news, the issue of diversity in police forces, because that's the most direct way in which people see an interaction with law enforcement. It's with the local police department as opposed to a federal prosecutor. But I think that we need to do a better job of making sure we're recruiting from everywhere and from everyone. I also think that people in various communities should think long and hard about whether or not in public service they can do a valuable service to the country generally, and most importantly, but also to the particular communities that they're identified with if they come in as prosecutors. And as I said, and as I think people note, but not often enough, a good prosecutor who exercises discretion properly can do more to save people than a defense lawyer who represents one client at a time. And I think if people had more of a sense that that was true, I think we would do a better job. I want to say a specific word on diversity with respect to women. So and I'll be very candid about this, we don't have an even number of women and men in our criminal division. We do in our civil division for reasons that are not clear to me. And I've asked the question of Neil, and we've talked about this, and we've hosted events. We had a very good event recently for all women law clerks in the Southern District in the Second Circuit to come and talk to them. And I left, and I wanted there to be a candid discussion about what life is like as a woman, as a prosecutor. And I think there's some misconceptions about that. But for whatever reason, when I went to law school, I graduated, and I went to the second best law school, right, at Columbia in New York. And when I graduated, there was still, don't tell them I said that at Columbia.
We're
there
not
was still a
recording.
lot more men in my graduating class than women. And I remember thinking, people would say, well, as years go by, as the number of men and women graduating from law school becomes more even, in particular at the elite institutions like this one, you're going to start to see more evenness in partnership ranks at firms and more evenness in prosecutor ranks, I guess. The first one certainly has not happened, has not come close to happening. And even in our office, we're not getting, we've analyzed the applications, and Neil can corroborate this. It's not the case that we're getting an even number of applications and we're disproportionately hiring men. We're actually hiring probably about in proportion to the applications we get. For whatever reason, we're getting disproportionately fewer numbers of applications from women to become federal prosecutors, even though the ranks, I don't know what it is here, but I think it's the case at many law schools that there are more women than men who are graduating in a particular class.
A lot of schools, it's around 50. Our 1L class has over 50% women,
Right.
54% women.
So I don't know. So that bothers me, and it concerns me. And we're talking about it, and we talk about it with the women supervisors in our office and with Neil. So I would encourage people, before you decide to apply, if you have any inkling that this is the kind of thing you want to do, I would get more information about it. I would go to forums. I would inquire. I would talk to. It's not that hard to find people, who are in the job and can tell you about it. And I think people don't appreciate. There's one speculation about women. I think there's a lot to balance, right, in life, and I've had those issues in my own life. And I think what people don't fully appreciate about being a prosecutor, it's a hard job. We work really hard, and we work long hours. But as compared to working in a law firm, which are also hard jobs, and you have to work a lot of hours, you often have, and this is counterintuitive to some people, a lot of flexibility when you work in a prosecutor's office, particularly if you're a senior prosecutor and you're trying to have a family. I mean, I'm not a woman, and I didn't bear my children, but I had 3 kids while I was an assistant U.S. attorney, and I didn't miss a birth. I didn't miss things because I had the ability, because I had so much autonomy. I didn't have a partner breathing down my neck and making me stay at the office till 1 a.m. to proofread a document. I could choose, if I wanted, to make sure I did my work on a Tuesday because the brief was due on a Thursday, so I could go to a birthday party on Wednesday, or I could go to a recital. All those things you can do. And I think people, it's another reason to go into public service. Often, not always, but often it's the case, you have more autonomy over your life, just as and how you operate during your day and what time you come in and what time, not always, than you might in private practice. And so I hope that's a myth that can be exploded a little bit.
It's a very persuasive case, so much so that Neil may need to go into witness protection, or he's going to be inundated with applications after this. Preet, thank you so much for being here today.
Absolutely.
Please join me in thanking. Thanks.